So, just to introduce you very briefly, Mr. Kapil Naik is a cost and management accountant working with a German MNC, and he has been doing research on Jammu and Kashmir for last 6 years. He is also associated with Jammu and Kashmir Security Council. That's a brief background of him, and he will be talking about the accession and developments around the accession, and maybe he'll give us a brief background on Article 370 also. Just now, what are the kind of arguments which have happened in the Supreme Court is the topic he will touch. And I'm sure, once the Supreme Court verdict comes, we'll again have Mr. Kapil Naik speaking to us. Over to you, Kapilji.
Thank you so much for calling me again. So just to give a quick background, what is happening in court and who has said what. Before I do that, I would still like to touch upon the political history of Jammu and Kashmir for another, say, 3-4 minutes, and then speak about referendum for another 3-4 minutes. But my focus would be largely on the proceedings that have taken place in Supreme Court about, I think, 15 to 16 days back to back, and on few of the days the judges have heard about 5 hours in a day. So you can imagine for 15 days to 16 days it comes to easily hearing of more than 70 hours. That is what Supreme Court and all the lawyers and this country has invested in, more than 70 to 80 hours in this debate on Article 370. And now we are all awaiting the decision. I really do not know if the judges will refer this to a 7-bench hearing, or there'll be a decision on this. So that remains to be seen. But as I said, some of the arguments that were made in Supreme Court, there were a battery of lawyers. There were 18 lawyers who were part of these petitions, and they challenged it differently. Supreme Court on day one said, or in fact, even before day one said, that we are not going to comment on the political wisdom of Article 370, whether 370 should be there, should not be there, under what circumstances it came into effect, whether those circumstances today they prevail or not, whether this is good for the nation or not. This is not going to be the part of the proceedings. This is what Supreme Court, I think, in a nutshell, they made it clear before the hearing started. But then when you speak of 370, you cannot keep the politics aside, rightfully so. And on the 10th day, the Solicitor General of India, he narrated one incident of Abraham Lincoln where somebody asked him about the choice between saving the Constitution or preserving the Constitution and saving the nation. If the choice is between the nation has to fall apart or split apart and preservation of the Constitution, what is the choice that we have to make? And then the answer given was by Abraham Lincoln is, I can sacrifice a limb for the body, but not body for the limb. The body is much more important than the limb. CJI quickly was fast enough to jump in the conversation and said, the ends and the means both matter. So that is how these conversations of this hearing was staged. On day one, I would like to also highlight, before I go into the brief history of 1947 and brief history of Article 370, because without that brief history, we really cannot understand what is happening in present. But now that I have spoken about day 10 beginning, I have to also speak about day 1 beginning and why this is important. On day 1, Kapil Sibal, I would predominantly speak about the arguments made by Kapil Sibal, because the court themselves made it that Kapil Sibal is the chief lawyer from the side of the petitioners, and all the other people who will argue, they will argue on what is left in the argument. They will not repeat what Mr. Kapil Sibal has already said. So this was the understanding clearly made on day 1. And the court on day 1 also requested Mr. Kapil Sibal that if you could finish off by the lunch on day 2. However, Kapil Sibal clearly said that he may take more time and he cannot or he may not finish by lunch on day 2. So he may need more time, but his lordship can decide accordingly after having heard him till the lunch on day 2. They may decide accordingly to grant more time or not. Now, what CJI said is extremely important, and I would say a milestone statement. It is a milestone statement in many ways. It is a milestone statement when we think of democracies, an institution. It is a milestone statement when we try to do a professional and sound guesswork of what Supreme Court is thinking. So in both ways, the statement is important. What CJI said on the day 1 morning to Kapil Sibal is, yes, I'm sure we would decide then by lunch on day 2 if to give you more time or not. But more than that, our conscience also has to be satisfied that we have heard. Now, this statement is really a milestone statement by CJI. He is clearly saying that we are not hearing this case because there is press, because there is international press, because there is domestic as well as international attention to this. We are not hearing this because we want to, satisfy either the government or the petitioners. We are hearing this because we want to be very clear in our mind before we make a decision that we have heard. I think this is a milestone statement, and this is, I would say, judiciary is one of the pillars of democracy. And by making this statement, our judiciary has made it very clear that we are not doing this exercise to tell the world that we have heard. We are doing this exercise because our conscience has to be clear that we have heard both the sides. That's really a fantastic opening statement by CGI, and I truly appreciate and welcome that statement, because in democracy, many times we are, when it especially comes to politics and political exercises and political decisions. We all have our strong views and we tend to get emotional. But it's important that keeping the emotion aside, keeping many times the political wisdom aside, we have to hear to the both sides. And I think this opening statement on day one is a milestone statement. What it also tells me is the case has started in 2023 and the inoperativeness, I'm not going to use the word abrogation of Article 370 or the cancellation of Article 370. And I would also encourage audience to stop calling it abrogation or cancellation. Those are technically not correct words. The technical word is it has been made inoperative, because that's what Article 370 itself mentions in clause 3, in point number 3, that it can be made inoperative in a particular way. So the word is inoperative. Yeah. And so the opening statement that our conscience has to be satisfied, this statement tells me that for last 4 years and even before that, Supreme Court does have a starting position on this topic. I do not know what is that starting position. Only probably CGI knows what is that starting position. At the end of it, he will have an end position. But what is important is that they do have a starting position, and this is my interpretation of this statement. Because somebody who doesn't have a starting position, he will never have thoughts of guilt and conscience being clear. Somebody who thinks that I have to be clear that I have heard both sides. Who is that somebody? That somebody can be somebody with a starting position. And what can be the starting position of Supreme Court on this? And after hearing what becomes whether they stick to their starting position, whether they change their end position somewhat, 100%, that remains to be seen. But what it tells me is that they do have a starting position on this. Take another 2 minutes to speak on 1947. If you have read a bit of history, we all know that the decision to accede to the dominion of India or Pakistan, the authority to take that decision, it lied with the head of the princely state and nobody else. The Government of India Act 1935 and the Indian Independence Act 1947, it clearly gave the power to decide, where do I accede, dominion of India or dominion of Pakistan? Where do I accede? That the power was clearly given to the head of the princely state. One argument which Mr. Sibal made on day one is a letter by Maharaja Hari Singh to Lord Mountbatten saying that he was contemplating if I should accede to dominion of India, I should accede to dominion of Pakistan, or should I stay independent. Now, very neutrally speaking, keeping the emotions aside, since the staying neutral is not an option as per the Government of India Act and the Indian Independence Act, there were only two options, acceding to India and acceding to Pakistan. But to stand up in Supreme Court and for Mr. Kapil Sibal to say this, frankly speaking, CJI, he wanted to stay independent. This is total and gross distortion of the history. There was Major Shah and an officer of Pakistan who came, I think somewhere in September, October of 1947 to India. He was sent by Barrister Jinnah. He came to Jammu and Kashmir to meet Mr. Mahajan, where he impressed upon Mr. Mahajan that Jinnah expects that the instrument of accession be signed in favor of Pakistan. Mr. Mahajan clearly told Mr. Shah that he has not made up his mind on which dominion to accede. In his conversation, he did not mention that he's contemplating to stay independent. Now, when there are documentary evidences that the contemplation, the thought was to accede whether to India or Pakistan, what gives any historical research right to Mr. Kapil Sibal to stand in room number 1 of the Supreme Court and say, frankly speaking, make a loose statement? Frankly speaking, he wanted to stay independent. Mr. Sibal is a very learned lawyer, and I don't think he makes loose statement in the Supreme Court. This is one way of creating an impression that Jammu Kashmir was a different state, It has a different relationship with India. There are many occasions which I'll run through his proceedings in court number 1, is trying to impress upon that this state is different, that the conditions of this state were different, and the state cannot be seen as any other princely state. And then the head of the princely state frankly wanted to stay an independent. So this is an impression which he tries to create, which is, as a historian, I don't 100% agree to it, right? If somebody is looking at option A, B, and C, I would put it as equally as 33%, instead of standing up in Supreme Court and say the option C was 100%. Frankly speaking, this was the option in his mind. So this is what I say. This is my submission, that Mr. Sibal is fighting a political battle in a court. Yeah. He also, Mr. Sibal, on day number 1, it's very, I do not know what, I'm going to focus on what Mr. Sibal said instead of what government said, because what government said, they have said it is the defense of the government, and it is there in the public domain, and I don't have to reiterate what government has said, because what government has said is it's their view, it's there in the public domain. And I think in this lecture I would pick up some of the pieces where Mr. Sibal has argued. I really do not want to go into what other 17 people have argued on referendum and stuff like that, because those are really minor points, and I would try to attack on the major points considering the shortage of time. Mr. Sibal on day number 1 said this is a historical day where the Lordship will be analyzing what was tossed up in 2019, whether the procedure was adopted and consistent with what democracy stands for, whether the will of the people was considered, this and that. And he again links instrument of accession with Article 370. And this is where the audience has to be very, very clear in their knowledge, and the whole of India has to be very clear in their knowledge, that the instrument of accession signed by Maharaja Hari Singh was in 1947. Specific date 26 October 1947. This is when Maharaja signed instrument of accession. The copy of instrument of accession signed by Maharaja Hari Singh is exactly same copy as what the other princely states signed. We have heard n number of interviews, not just Kapil Sibal standing in court number 1 on day 1 saying this, but we have heard n number of interviews of Abdullahs and Muftis saying 370 is the basis of relationship. Answer is no. The argument is no. 370 was never the basis of accession. In a way, in a subtle way, everyone is trying to tell us that we acceded because there was a special relationship, and without that understanding of special relationship, we wouldn't have acceded. First of all, Mr. Abdullah or Madam Mufti did not accede. They must be very clear that they are not that important. The right of accession was with the head of princely state and not with Sheikh Abdullah. So when Mr. Farooq Abdullah or his son Omar Abdullah today says that we acceded based on a special relationship, and they hinted that way, if not directly and with an indirect hint, let me make it very clear that your family and Mr. Omar Abdullah, not your grandfather, he was not party to the accession. It was solely responsibility of the head of princely state to accede to either dominion of India or Pakistan. That's number 1. So don't say that we acceded. Yeah. And the point number 2 is that the Article 3. Now I have to give a bit background of Article 370, how it came. It came as Article 306A. Yes, that was the original number of Article 306. And I have to tell you this, the whole argument on day number 1 and 2. So Mr. Sibal has slightly touched upon the political wisdom of it. He did not stretch it because the courts were clear that we don't want to hear the political wisdom of it. But then on day 2, Mr. Sibal also made some political comments, which I'll cover in some time. One of the very strong argument made by Kapil Sibal is about the temporary nature of the article. The article itself says it's transitional and temporary. These are the 2 words. I think court has consumed a lot of time, and Mr. Sibal has consumed a lot of time in explaining what is temporary. And then I'll comment on and I'll argue on Mr. Sibal's argument of what is temporary. So when Dr. Rajendra Prasad, the entire constitution was ready. Dr. Rajendra Prasad was going to accept preamble of the constitution in the Constituent Assembly. The whole of constitution was ready. And before that whole of constitution was ready, Sheikh Abdullah or Nehru, or in a way indirectly, both of them, directly or indirectly, approached Mr. Ambedkar to include Article 306A in the Constitution of India. These are words of Mr. Ambedkar. If you want me to include this article in the Constitution of India, this is treachery to India. These are words. These are not my words. I'm not paraphrasing. These are words of the man who was heading the committee to frame the Constitution of India and submit it to the Constituent Assembly of India. These are his words that this is treachery to the nation. He refused to include this. When he refused to include this, it was so last minute that when preamble of the constitution is to be moved in the Constituent Assembly, and Dr. Rajendra Prasad said, let's take the preamble. Mr. Mohani, one of the member of parliament, if Maulana Mohani, if I remember his name rightly, he said, no, there is one article pending. Imagine how last minute this is. If something, now the argument is, the hypothesis is Article 370 is the bedrock, is the connecting bridge between the state and the dominion of India. That's the argument. First of all, legally that gets thrashed because the instrument of accession is signed in 47. It's unconditional accession to India. It's irrevocable document and it's not a conditional document. It doesn't mention Article 370. Article 370 came much later. So the argument that this is the bedrock of the relationship gets destroyed legally there, timeline-wise. The argument also gets destroyed in Government of India Act 1935, where it doesn't mention any of such article to establish relationship between the state and the dominion of India. Point number 3 is, which I want to make, is that the article came up such last minute inclusion when all articles were taken up and that the preamble of the constitution was removed, and Mr. Gopalaswamy Iyengar, last minute, Gopalaswamy Iyengar was also the ex-Prime Minister of Jammu and Kashmir. He was an IS officer from Chennai. I have not found any historical evidences how a IS officer from Chennai managed to become Prime Minister of Jammu and Kashmir. I really don't know. I'm yet to find any conclusive evidences for reasons for his appointment there somewhere in 1936. But later on, he went on to become, I think, Kashmir Affairs Minister for Dominion of India. And then he brought up this Bill 306A. And the bill itself said that this is temporary. Now, if something was so important, it wouldn't come up last minute. That's the hypothesis I'm trying to build. If something is important, we all know some of the students, they study last minute, just before the exam. But constitutions are not framed like that. The important relationship between the state, the acceding state and the dominions are not framed like that. If something is bedrock, you call it something bedrock, essential part of a relationship, it doesn't get introduced when the preamble of the constitution is about to get introduced. It doesn't get introduced without permission of committee of Dr. Ambedkar. So when this article was introduced, that's the hypothesis I'm trying to build as a student of Jammu and Kashmir, that this was so insignificant for the relationship between Jammu and Kashmir and Dominion of India that it came up last minute. And when this article came in, obviously, I think we all might have read this article by now. It says that for all the matters mentioned in instrument of accession, So there was a union list where there is list of subjects where union government can make laws, and there is a state list where the state government can make laws. There is a union list and there is a state list. So as far as the union list is concerned, if the parliament has to make laws for the line items in the union list, it needs to consult the Constituent Assembly of Jammu and Kashmir. This is what the crux of Article 370 is. And another point which I would like to make is Mr. Sibal has referred the will of the people so many times. Now in my last lecture, I think I've completely destroyed the myth of plebiscite, and I said that argument is totally junk and India should totally forget it, because it was not the will of the people that brought Article 370 in first place. It was the Republic of India, the would-be Republic of India, they got the Article 370. And in fact, the 4 members of Jammu and Kashmir in the Constituent Assembly, they never spoke on Article 370. Can you believe that? And one of the members was Sheikh Abdullah. He never spoke on Article 370. It was not will of the people that Article 370 got into the picture. It was never the initiation from the people that people demanded, we want will of. So the logic is, if people never demanded it and it was the federal or central government of India which brought this article, the central government definitely possesses the moral right to take it out without really debating what is will of the people, which is a separate topic. And I've clearly given, I think, list of 9 to 10 questions why the argument of plebiscite and referendum is totally junk argument and it should be thrashed and forgotten. But I'll still mention one point here, because one of the lawyers from the petitioner's side, he referred to a referendum like Brexit. So the CJI, the good news is the CJI has clearly said that the Constitution of India does not recommend referendum of any sort. That's clearly been thrashed by the Supreme Court judges that it does not, our constitution does not recommend referendum. That's clearly over and out. That's point number one. The next day, Times of India wrote a fantastic editor's column. I don't know how many of you have read that. It wrote a fantastic editor's column after CGI said this, where it said that all those who advocate a policy of referendum, they should know that referendum is not the smartest way of including will of the people into policy decisions, because critical decisions, the critical decisions related to national security and economy can't be left to be decided by a simple yes and no type of question to a layman who has got no study on the subject. So that's a beautiful editor's column written by Times of India. Anyway, I've given long list of 10 points. You can refer to my previous lecture where I said the whole discussion of plebiscite and referendum is a myth. It's a junk. It's all propaganda, and India should completely forget this word ever in context of Jammu and Kashmir. And I've given technical and legal reasons for it to be so in my previous lecture. Now coming to day number 1, 2, and 3, as I said, I'll stick to some of the interesting points that were made by Kapil Sibal. I've already spoken about how Kapil Sibal said, frankly speaking, the Maharaja wanted to be independent, and this is historically, I would say, a not a sound conclusion to be drawn. Now, what is the whole argument of Article 370? The whole argument of Article 370, the whole argument by the petitioners is how did government achieve this? Number one is the temporary nature. Kapil Sibal has made a statement in Supreme Court on day 1, 2, and 3 repeatedly about his interpretation of what is temporary and what is transitional. I will offer my counter views on what is temporary and what is transitional, and then I'll give you good news of what CGI said on what is temporary and what is transitional. So what Kapil Sibal has argued is the Constitution of India, we changed ourselves from dominion to a republic on 26 January 1950. And at that point of time, although, as I said, Baba Saheb Ambedkar Committee did not recommend Article 370, somehow through Constituent Assembly debates, it came into the picture, and then it was inserted into the Parliament, into the Constitution. And then finally, when the Dominion of India became Republic on 26 January 1950, we like it or not, we find it appropriate or not, we may justify or not, Article 306, which will later on become 370 by revised numbering, became part of the Indian Constitution. And this Article 370, mentions Constituent Assembly. Now we have to understand what is Constituent Assembly and what is Legislative Assembly. And if there was no Constituent Assembly in 1950 in Jammu and Kashmir, why did the word Constituent Assembly came into the Constitution of India? So let me clear, I think a lot of similar words, it may sound confusing for those who have not read a bit of law, but I'll try to clear all those doubts. So the definition or the purpose of Constituent Assembly is Constituent Assembly has a limited purpose. It has a limited life because it has a limited purpose. The purpose of Constituent Assembly is to frame a constitution. It cannot have a partisan view. A legislative assembly is the one which is involved in the governance of this country. Yeah, but the job of Constituent Assembly, it has got a limited life. It makes a constitution and then it's over. So India had a Constituent Assembly which accepted Article 370, and that Constituent Assembly naturally got dissolved when we became republic. Jammu and Kashmir was also going to have its own Constituent Assembly where it would be making their own constitution. And Gopalaswamy Iyengar in his debate in the parliament said, why do we want Article 370 when other states we are not recommending Article 370? These are words of Gopalaswamy Iyengar. He said, the situation in Jammu and Kashmir is unique. It's unusual. Rather, the word is unusual and abnormal. These are the two words used by Gopalaswamy. What are the words? The situation is unusual and the situation is abnormal. What is unusual and abnormal in J&K according to Gopalaswamy Iyengar, who tabled this bill? Jammu and Kashmir was in state of war at that point of time. India had wrongly gone to United Nations, which I have covered in my previous lecture. So there was a state of war. Some part of the state, the whole of state acceded to India, but some part of the state, it was still in occupation of Pakistan at that point of time. Unfortunately, it is still in occupation of Pakistan as we speak today. So there is a special situation there, and to facilitate application of Constitution of India into Jammu and Kashmir, because it's a special situation there and the situation is likely to get resolved in some point of time, we need this special mechanism of applying Constitution of India to Jammu and Kashmir. That was the whole purpose of Article 370, and according to me, this is the limited purpose of Article 370, and that is why it is called temporary and transitional. It was never supposed to last for 75 years. If this is what Supreme Court has also asked during the hearing, that if something is temporary, something is transitional, how can it last so long? How can it outlive its purpose? Now, the whole argument which Mr. Kapil Sibal has made is this. The clause 3, the clause 3 in Article 370 says this. It talks about how this is the only article, by the way, in the Constitution which says, how can you kill me? How can you make me inoperative? This is the only article which says that. And Article 370 says that president, the executive, the president by a CO, constitutional order, provided it is recommended by the Constituent Assembly of J&K, if both these conditions are satisfied. What is condition number 1? The Constituent Assembly of J&K recommends, and then president releases an order, this article can become inoperative. Mr. Sibal admits to this, that this can become inoperative provided two things happen. One, the Constituent Assembly recommends, and second, president passes an order based upon the recommendation. The whole argument of Mr. Sibal is the Constituent Assembly of Jammu and Kashmir, it was established in 1951 and it got over in 1957 because it made its own constitution. So the Constituent Assembly ceased to exist in 1957. Now there were two powers. The powers lied with two people or two institutions. One, Constituent Assembly, and other president. If the Constituent Assembly is gone in 1957, that means now this article cannot be made inoperative. The temporary article has naturally become permanent. This sort of weird argument, I am using the word absurd and weird to this, is presented by Kapil Sibal. He may have spoken for 10 hours in the court, but this whole argument is, since Constituent Assembly got dissolved in 57, they did not make it inoperative. Now nobody can make it inoperative. Now I'll try to answer this in many ways. And there's a famous lecture of Honorable Mr. Arun Jaitley, where he has spoken about absence of power. So basically, if the power is vested in A and B, my argument is this. If the power is vested in A and B, A is still there, the President of India, that position is still there, but B died in 1957. What I mean is died, it ceased to exist. The Constituent Assembly got dissolved in 1957. So power in B is not there. So should we take a position that because B is not there, the article has become permanent and nobody in the world can touch it? This can be argued in many ways. What is absence of power? The absence of power can be interpreted in many ways. Absence of power means the proviso to this, the provision was that the Constituent Assembly recommends. The absence of power in B means, or the absence of B means that the power which was given to B is absent. So the power vested in A, the power given to A is sufficient and final to take a decision. This can be one way of looking at it. Another way of looking at it is, so B is absent, so the power in B is absent, it is not required, it is redundant, and A is sufficient to make it inoperative. That can be argument number 1. Another argument is, if B is gone, then who has replaced B? That's the question. And this is the route the government of India took on 5th of August 2019. With an amendment to 367 of the Constitution, the government of India substituted word Constituent Assembly with the Legislative Assembly. So we have to understand this sequence, what government of India is done on 5th of August. So in 2019. So in 2018, there was a president's rule, using Article 356. There was a president rule. So the Legislative Assembly is dissolved in Jammu and Kashmir. There was no government. There was president's rule. So when Article 356 comes into the effect, two things happen. The governor, I'm using a very simple word for common people to understand, the governor replaces president and the Legislative Assembly is replaced by parliament. Governor by president, Legislative Assembly of state by parliament. But there is still a problem. The problem is the Article 370 can be made inoperative only by recommendation of Constituent Assembly, which got dissolved in 57. So what to do now? Then government used amendment in 367 to replace the word. Government has replaced the word of Constituent Assembly by Legislative Assembly. And the moment that replacement takes place, the power of Constituent Assembly gets shifted to Legislative Assembly, and the power of Legislative Assembly gets shifted to the Parliament. Yeah, because there is precedence rule in place, and this is how government has imposed 356, amended 367 to change 370, and then use 370 to make it itself inoperative. It's as simple as that. This is what government has done. As I said, was amendment to 367 necessary? This is what Chief Justice Chandrachud also asked this question. Why this is necessary? Yeah, because if the power is absent, this is what Arun Jaitley's famous speech also said, that if the B is absent, if the power in B is absent, then we can assume that the power in A is full and final, that the power in President is full and final, and that is sufficient to make it inoperative. We really don't need to substitute Constituent Assembly by Legislative Assembly. We really don't need to amend 367 to change that wording from Constituent to Legislative Assembly and then discuss it in the Parliament and then make Article 370 inoperative. Now I'll talk about the political angle of it. My interpretation of this is signature of the president was sufficient because the Constituent Assembly is anyway not there. And Kapil Sibal's argument that because Constituent Assembly is not there, the temporary provision naturally becomes a permanent provision. Yeah, I refuse to agree with that level of argument. Now, my understanding is, why did then government took extra precaution by changing the word Constituent Assembly to Legislative Assembly? They might have done it without it, according to me. I don't know what Supreme Court will decide. I'm not CJI. But government has taken extra precaution by changing the word from Constituent Assembly to Legislative Assembly. That's an extra precaution which government has done. And the reason government has done is not because the case has to stand in Supreme Court in 2023. I think the reason government did this because they wanted to see who in Parliament is in favor of making 370 go, make it inoperative, and who is not. Many times we classify our politicians as BJP and Congress, this and that, and we think that the 545, they are vertically split like this side and this side. But trust me, there are occasions where governments in present and past have been able to pass a bill with their own party not having 50% majority. That means there are parties which are in opposition. They still vote for a particular bill. They don't need to support the government for 5 years, but they think that this particular bill is important for the nation. As I said, the Abraham Lincoln's quote in the beginning, that you cannot sacrifice the body for the limb. You have to make a choice. Yeah. So this is what government wanted to see out of 545 members. Of course, government knew where the NDA stands on this, but they also wanted to know who in non-NDA parties, where do they stand on this? Yeah, they wanted to understand where do they stand for this, and that is why they took extra step of substituting Constituent Assembly with the Legislative Assembly using 367 and then made it inoperative. Government has not said this. I am not spokesperson of the government. So this is not official stand of BJP or NDA or Prime Minister or the Home Minister. This is what my interpretation of what happened is, that government took extra precaution to substitute the word. They could have just gone ahead by simply presidential order and said this is inoperative. Constituent Assembly is anyway not there, so I don't have to consult anyone. Government presidential order done. But they have gone one extra step and substituted Constituent Assembly by Legislative Assembly. Maybe, I don't know, I'm just guessing that yes, maybe one reason that this case has stand in Supreme Court, and second reason they wanted to see who's in favor and who is not favor. So that is what happened on 5th of October 2019 after the 370 was made inoperative. The Attorney General has said, representing the Indian government, that total of 12,000 pending laws have been applied to Kashmir. Jammu and Kashmir no doubt acceded to India when the instrument of accession was signed. There is absolutely no doubt about it. That is irrevocable, unconditional, doesn't need a plebiscite or a referendum. It's unconditional. And the whole of Jammu and Kashmir in 1994, 24th February 1994, it was in fact the UPA government which passed a resolution in the parliament saying that by all means, political, diplomatic, and by all means, which is non-political and non-diplomatic, that the entire Jammu and Kashmir is part of India and we have a resolution. So India is committed to that. But with inoperativeness of Article 370, I think the integration of Jammu and Kashmir, the legal integration of Jammu and Kashmir is complete. Now what is important is people-to-people integration of Jammu and Kashmir, where it is very clear that we cannot keep a territory without its people supporting us. So it's important that government and non-government organization, they work towards integration of Jammu and Kashmir. The mind, dil se dilon ko milna zaruri hai. The mind integration of Jammu and Kashmir There is a lot of garbage and misinformation. In fact, I always, the Jammu Kashmir Study Center always said that the problem with Jammu and Kashmir is not in Jammu and Kashmir. The problem in Jammu and Kashmir is the whole set of misinformation that has gone on and on, like the plebiscite, the referendum, that this was the bedrock, that this can't be removed. Khoon ki nadiyan behengi if this is big. That the whole set of garbage and misinformation that has gone around for many years, 70 years. I hope, I do not know what CJI will decide, as I said in the beginning, whether they'll refer it to the 7-bench judge or they will. I do not know which way this will go. I only hope that the decision taken by the government stays valid and we do not see face. We only see back of Article 370 and not face of Article 370. There are many arguments which have been made. I'm just saying if I missed out. Yeah, I was saying that the CJI, this is the one thing which I would definitely like to share. It was a classroom. I would encourage that, this is I think day 2 or day 1. CJI explained what is temporary and what is transition. This is historic. What CJI has said is temporary means something which is for the limited period, but without knowledge of the point of terminus. It is temporary, but I don't know where, how, and when it will end. That is the meaning of temporary. And the meaning of transit, but it is temporary. It is not supposed to last forever. The meaning of transitional, according to CJI, is something which has a terminus, something which has to end. And Article 370 is both temporary and transitional, which means it is not supposed to last forever, and it should have an end point. And I think this was a school, and Mr. CJI has made it very clear. I think these two statements of his, and then he has made many politically close statements also. He also raised a point on, I think, day 3 or day 4. He says, how is that, Mr. Sibal, you say that because Constituent Assembly got dissolved in 57, this temporary naturally became permanent? How can you say that? What if, let's assume another hypothesis, CJI says, what if today the will of the people is to get rid of this? Are you going to tell people, sorry, even if it's your will to get rid of it, you can't do it because the article uses the word Constituent Assembly and it got dissolved in 57. Now nothing can be done. Now this temporary has become permanent. So are we saying that even the will of the people, say for example, this has to be made inoperative, which I believe is there, that this can't be touched upon? So I think all this questioning and thrashing of referendum which CJ has done, I have little doubt in my mind that that Article 370 will come back and will become operative. I have very strong faith in our judicial system and the wisdom of our learned judges, and I have strong reasons to believe that this will stay inoperative.
Sir, my apologies for lying and slanting because I have back injury. So apologies for that. If I were in a state of Israel, or since I am a part of US right now, being an American citizen, those kind of things are not admissible in US. We cannot debate here whether Texas can be part of United States or it should be part of Mexico. I mean, because as you know, once in a while, like Texas had a majority of part ruled by Mexican government, and it was annexed when the independence happened. There is no debate about that, about the territorial integrity or anything. Once acceded, once it's given. And we have wasted like more than 75 to 80 years fighting on it. Our resources have gone there, and we have given a space to several nations to debate about the freedom of and territorial integrity of a country, which is none of their business. That is number one. I think the time gone is gone. But when the judgment is due, sir, for this?
So I really don't know. I mean, Supreme Court has not given any hint on this. Coming back to your point number 1, I fully agree with you that that our sovereignty is, our territorial integrity is not for sale. Number 1, it is not up for even discussion. It is not up for negotiation. And I think we are very clear about it.
And one more statement I think CJ has made is that we are safe as long as the country is safe. See, some of the famous statements I'm just recollecting. Right. Okay. Yeah. That's right. Okay.
That also again goes to what the government representatives, the Attorney General has said about the story of Abraham Lincoln, the body and the limb story, right? Now we can't have a fantastic constitution when there is no nation. Yeah. So we do not want to be in that situation. However, CJI made a balancing statement that the ends and the destination and the means have to be equally right. But then it is equally accepted that we can't have a constitutional book without a nation. We don't want to see that thing.